Welcome back. We have Michael Gullo and Christina O'Shea, and we're here with section four, the final part of our training module today. And this is trial preparation and trial. For us, oftentimes these cases, when we're ready to go to trial, decision has been made to go to trial. We're going to try this case. Either it's going to be tried on a threshold damages issue or a liability issue or both. Oftentimes, the courts will bifurcate trials. What that means is that they'll have two parts, two separate trials, one for liability, one for damages. If it's a simple trial with only a couple of witnesses, the judges can put them together. Judges like to bifurcate trials because once liability is established, that opens up some meaningful settlement discussions. So preparation is really the most important part to all of this. We spoke about being over prepared before. Trial preparation is significant, takes time. We develop questions, we subpoena records. So the note of issues filed, all the motion practice is over, and everybody's still in the case. And now we make a decision. We're going to try this case. We can't settle it. Our settlement offer, let's say, is 25,000. A plaintiff's demanding 500,000. We're not even close. The conferences that come up once the note of issue is filed. Well, the note of issue conference, if you ever hear of the word certification conference, that's a conference where the judge declares that all discovery is completed and gives the authority to the plaintiff to file the note of issue. There's usually a deadline on that. And then they need to file the note of issue to certify the case it's ready. It goes on to the trial calendar. The judge will have one, depending on the parts, one, two, or three pretrial conferences or settlement conferences where the judge will conference the case, get an idea of what's going on. And the judge that we had throughout the entire case, if it's the same judge, will likely not be the judge that's going to be the trial judge. We get assigned to a trial part. Now we get a new date. We go into our trial part. There'll be a judge sitting in the trial part, and it'll be the judge in charge of that part. And the judge say, "Who's ready? You're ready. Let's go. Go pick your jury." And that's basically what happens. The jury selection process is a is an interesting process in and of itself, but the pretrial prep, medical records, plaintiffs need to subpoena the medical records with fresh authorizations to the record room of the courthouse. And that's done to ensure that there's a chain of custody and that we know that those are the original legitimate records that are sitting in the courthouse waiting for the trial. Plaintiffs do that to show readiness. Once they file the note of issue, if they start subpoenaing records and they're done with that process, that means they're ready to go. You know, if we see plaintiffs delaying on that process, maybe they really don't want to try the case or they don't want to go through that effort. Witness preparation, of course, is key. We do discuss these facts with our witnesses for these trials. We like to do that in person, especially in the Supreme Court, because these trials are usually going to be in person and live. So for us to interview our clients in person helps us get a little bit of an edge to know what type of testimony they're going to give or what kind of a witness they're going to make.
Right. And at that point, we're obviously providing the witness with clear guidance. We're giving them expected questions. Sometimes we're doing mock trial examinations.
Most of the time.
Right. We're looking at, we're trying to push them a little bit so that they could feel that pressure, the pressure that we spoke before about, in that courtroom setting.
Yeah.
And so I think this, for me, professionally speaking, I think is probably maybe the most important thing is that witness preparation. Obviously, it's up to us to know the judge's part rules and so on and so forth. But in terms of the expert preparation, I think that's very key at this stage. At this point, the attorney has to be exceptionally well versed in the
Yeah.
case. Of course, getting your exhibits together, putting binders together, putting the documents together. That's to be organized is crucial, but
Yeah.
the attorneys ideally know every little thing about their case up until this point. Right now, the only thing that is can turn or change the case is a witness's testimony. That's my opinion. I think
Yeah,
it's
the wit,
it's crucial.
yeah, and the preparation, we're very careful. We do not ever want to give a witness an answer or what we think or they think they should be saying because they're going to mess that up. They're not professionals most of the time anyway.
Right.
And you don't want to give them what they should be saying. We ask them to just tell the facts, tell the truth, answer the best you can. If you don't know what the answer is, don't guess. But on well, before we go to trial with these witnesses, we will spend some time like this, and again, in person if we can, basically questioning them, cross-examining them on some of their points to see if they're even telling us the truth and to make sure that they're prepared. Like, this is the type of thing that's going to come at you at this trial, so you need to be prepared for that.
Making them a little uncomfortable, right? I
Yeah,
mean,
of course.
you
Yeah,
want to ask them the uncomfortable questions. And quite frankly, we don't want to be standing there and be surprised. So this is the time, if not before, if I didn't discover something that I didn't know about earlier upon prepping them or
mhm.
interviewing them, discussing this case with them, at this point, I am making 100% like I am certain that I am not going to
Yeah,
be surprised at the
mhm.
time of trial.
Yeah,
I always tell a witness to be very honest with us at
mhm.
this, especially now, more
Yeah,
more than ever,
yeah.
right?
And pretrial reporting, there's a pretrial report that needs to get done. And in that pretrial report, we'll give an analysis of the arguments that we're likely to see, the positions people are going to take, who the witnesses are going to likely be. We give recommendations as for pretrial settlements and the numbers. We do jury verdict analysis, and that's usually done a little bit earlier than right on the eve of trial. We'll do it once we have the IME and we know the depositions are completed. We'll do a pretrial jury verdict analysis to take an analysis of the injuries and to see what other juries in that venue have awarded so that we have a good idea of what we're looking at. If there's a $100,000 policy and this type of a broken bone or with surgery, juries have awarded 250, 300,000. We want our client and the insurance adjuster and carrier to know what their potential exposure is on this case. So that's a good part of it as well in our preparation. Scheduling witnesses and experts, we contact our expert, have a discussion with them, depending on the doctor. Some doctors we have a relationship with, we're like, hey, Dr. O'Shea, you know, we have this trial coming up. Are you ready? Yep, I reviewed my IME report. I'm ready to go. Great, doc. Great. See you there. And it's that simple because they know what they're doing. Some doctors need some a little bit more preparation going through their records, and we question them on things. Doc, how are you going to explain that you found a limited range of motion in their cervical spine, yet saying that it was resolved? How are you going to answer that question? We try to get that up front. It really depends on our expert. That's why we try and pick them because some doctors don't even like to talk about that stuff. They don't want to spend the time prepping. And oftentimes they charge us for prep time. So we try to limit as much as we can, of course, the financial consequences of that.
We also tend to analyze and assess how a particular jury in a particular venue is going to be either receptive or, you know, how they would view our witness, whether it's our witness, whether it's our doctor. I mean, we take all of that into account as well. And
Yeah.
sometimes typically juries, we have an idea pretty much. Obviously, the jurors change, but the venue in the courthouse and the judges that are in those venues, we do like to assess, and that definitely comes into our trial prep, how the judge is going to receive our witness, how the jury is going to receive our witness, whether that's the doctor or, an insured operator or any witness, really.
Yeah, when I worked in the courthouse, I spent a good deal of my career inside the courthouse, working as principal court attorney, so in the Supreme Court, and the juries do wacky things. One of the things we did, I've observed and did jury and written jury instructions and watch trials from the inside perspective. So this way, when all the attorneys, everybody leaves, we used to sit and have a conversation with the jurors, like, why did you go that way? And sometimes they just don't like the lawyer or they don't like the doctor. We had a doctor, it was a Richmond County Supreme Court case, and the doctor was being sued for malpractice. And he was from Harvard. It's okay. But all he kept telling the jurors, I'm a Harvard trained doctor, I'm this. And they didn't like him because of that one. That's why they ruled against him for that one thing. They
Yeah,
just didn't like the way he came off.
it's
So,
true.
yeah,
I knew an attorney actually where he pulled the jury after, and one juror told him, I didn't like the shade of orange tie that you were wearing.
it's crazy stuff
And
like
it could be like as ridiculous as that,
they are
right?
wildly unpredictable. So
Yeah.
when we're comes time, what'll happen is once we get to the point where we're ready to go, we'll get in front of a judge and a judge will say, okay, let's go pick a jury. Depending on the judge part, the type of case, some court parts have what they call direct select. And that means it's not like the movies where we go and we spend all day questioning the potential jury pool. So the jurors, I'm sure most of us know now by now what jury duty is. The jurors, voter registration cards, licenses, they get called down to come to the courthouse. They get randomly selected. And then a direct select, there'll be a panel of jurors who have been screened by the court actually answering questionnaires. And they'll be all sitting in a room. And then the attorneys go back and forth picking jurors that they want without so much of the questioning or challenges or different types of striking them that would normally go on. This kind of speeds up the process a bit and allows it to kind of move freely without, I guess, without killing too much time for the court.
Yeah.
It skips the traditional voir dire. You've heard of that, the questioning by both parties. Both parties generally, if they agree, let's just go, direct select. Like let's go pick a jury and we roll out. The other aspect of it is a jury panel that gets selected. Prospective jurors come in, and then there's a preliminary screening done at the court level. They talk age, citizenship. If somebody says, I'm prejudiced, I don't like anybody with a green shirt, they might just knock them off immediately right there at that stage. Then the next stage comes the voir dire, the attorney questioning, where the two attorneys basically get to know the jurors. We have conversations with them, and we get a feel. So, if we have a juror and say, Mr. So and so, have you ever been in an accident before? Yes. Oh, what type of an accident? I was rear-ended by this guy and he should have paid me millions of dollars because I got hurt. That's not a guy that we're going to want on our jury. Some jurors do show up and they are actually quite straight up prejudiced. They don't like the witness because of the color of their skin or the color of their hair or their race or ethnicity. We're allowed to knock those people off, knock them off. You know, Potential biases. Do they know the witness? Do they know any of the parties or the judge? Things of this nature. The panel will be six jurors get selected. There'll be usually two alternatives in the Supreme Court, and the alternate jurors will sit and listen to the entire case just in case one of the six jurors on the panel gets sick or something happens and they need to be discharged for whatever reason.
Actually,
Challenges, yeah, go
actually,
ahead.
before we get to the challenges, funny story for our audience is that when I got picked for jury selection, they asked me what I did for a living, and I told them I was an attorney, and they asked me who I worked for or where I worked, and when I said it, the attorney that was actually selecting the jury had gone to law school with you or your brother. I forget which.
We're both of us
And,
because we went
and I
together.
and I got kicked off. They wouldn't even take me.
You got lucky.
Yeah.
You know what? You'd be a good juror, though. Maybe you didn't get lucky. You should sit it. We have spoken to jurors. I've spoken to so many of them, and some of them love the experience. They are actually it turned out to be a good experience for them.
Yeah.
So, as with questioning jurors, you do get challenges for cause. Challenges for cause if somebody admits a bias or there's a conflict or there's an impairment, things of this nature can be justified. We do get preemptory challenges where we don't have to give a reason. There's a limited number of those. Just I don't want this person. It just, the vibe isn't right. You can do that. Usually you get three of them per side. If there's multi-party actions, it could be more. Um, you can't, when we do make the preemptory challenges, we can't make that decision as attorneys based upon our own bias or any other kind of bias. There's a case called Batson. It was a big section in law school on how to do this. But generally speaking, in a nutshell, we can't discriminate against jurors for any particular type of bias. Then we select our alternatives after the main jurors. The jurors then will get sworn in by the judge. Then everybody kind of hangs around and waits for the court to get the trial rolling. So the trials, depending on the judge's schedule, they will try and schedule in advance when witnesses are going to come. Your witness is going to be on Tuesday, your expert's going to be on Wednesday, your expert's going to be on the following day, and they try and schedule it the best that they can. Um, the theme or the theory of our case from the beginning that we spoke about what our actual theory is, what our story is that we're going to be giving the jury. That's at this point where this becomes followed through on, especially in like opening statements and things of that nature. So the trial, once the jury's assembled, we have dates, everybody shows up day one. In its simplest form, the plaintiff will do their opening statements. The defendant will do their opening statements. The judge will give some opening remarks. He gives and he'll go through his list, his basically his little speech of pre-trial jury charges. A jury charge is what the law read to the jury. I think I mentioned the PJI and trial strategies and tools. Those are jury instructions. They come from a book, the pattern jury instructions, and the attorneys will submit to the judge what prior to the trial starting, what charges or rules or sections of this PJI that we want the judge to read to the jury. The judge usually has a set form depending on the case. For like auto accidents, they know what they want to do. So we'll submit if we want extra charges put in, such as there's a thing called a missing witness charge. Or if our defendant doesn't show up, there's a charge that the judge will read to the jury explaining to them what it means that the witness is missing. Not a good one for anybody who's missing their witness, but that's the type of, they have negligence, they'll define it. The judge will read, part of the claim here is negligence. Negligence is, and he'll read the law to the jurors. Often there could be a bench trial. A bench trial means that the judge is the one trying the case. And Christine, I know you just recently had experience with what we call a summary bench trial, where we submit all the
Yep.
documents and
Great. And that was a decision by obviously both parties come to that agreement.
hmm.
Um, yeah, I mean that streamlines certain aspects of this of the case, and in certain circumstances it's warranted, really.
Yeah, I agree. Sometimes the judge will be in a better position to make a decision as a trier of fact. So the judge has to try to conduct the trial at the same time as being an impartial trier of fact, if there's such a thing. So defense focus. Oh, jumped ahead. Defense focuses on, you know, potential biomechanical low impacts, surveillance videos, depositions. These all have to now be an admissible, not only an admissible form, but they need to be put in as evidence. We can't just show up and say, oh, here's a police report, jury, go look at it. We can't do that. We have to get it into evidence in a proper way. Someone needs to identify this document for what it is, for the truth of what we're asserting. It's a whole laundry list of hearsay objections and business records. These are evidentiary rulings, which is in two full semesters in law school and probably should be more. It's a complicated area of the law for sure. But that's where things come in. For this particular presentation, we talked about deposition transcripts. They can be used if the witness isn't available. They can also be used to impeach a witness, where they said one thing at their deposition and one thing at trial. So, for instance, if somebody said, I I didn't see the light change at the deposition, and then at the trial, they so I did see it change. We would pull out the deposition transcript. We would say, well, on such and such a day, do you remember giving a deposition and you were asked this following question and gave the following answer? And they'll say yes. You'll say, well, wouldn't your recollection be better then than it is now? So impeaching the witness, showing that they didn't tell the truth about something, could jeopardize the entire testimony because now they lied about one thing, they could potentially be lying about the rest. You have anything to add? I know we could go on.
No, I mean, right. I mean, we could really elaborate on each of those points. Obviously, in the back of our mind, we're also considering that cost benefit analysis, biomechanical engineers to bring them in. That's not cheap. To have those reports, that's also not cheap. Again, we harken back to the same theme throughout, which is keep the adjusters on the same page. Everybody's making these decisions as a team effort.
The
Um,
adjusters are on call.
and they're on call.
When we're
And
going to trial and you're working with us or the defense firm, it's going to be, all right, we're starting at 10 o'clock, like be available. Because at any point during this trial, there might be a break and settlement discussions might be coming up. A judge always wants to settle these cases before, once the jury's picked and everybody's ready to go, the judge will sit the parties in the chambers most often and have a discussion, where are we at? And they really try their best to find a resolution and not have to go forward with the trial. But once we're in it, at any point in time, settlement discussions can be had. Comparative fault is just a reduction in the percentages, of liability and recovery. High-low agreements are oftentimes we'll go into trial and we'll all agree, right? The most, we can't settle the case, but it's at least worth 25, not more than 100. So 25 is the low, 100's the high. So if we go in and there's a verdict for 250,000, the most they're going to get is 100. If we go in and we win completely and there's no damages, they're going to get their 25. It protects everybody a little bit going into the trial. Structured settlements that should be talked about more in the settlement section, but we talk about it here with the potential outcomes because a structured settlement is something that gets settled but gets paid over time. There are certain investment tools and there are companies who finance these structured settlements. And it's basically, okay, you're going to get $20,000 now, another $20,000 in a year, another $30,000 2 years down the road, and there are time frames on that. We do that sometimes with infants, if there needs to be a settlement done so that, they're not going to take possession of these funds until they're a little bit older. So this way they're managed properly. A mistrial is rare, but happens. A mistrial is when something wacky happens that shouldn't have happened, and the judge declares a mistrial, and you start all over from scratch. We try to avoid that the best we can. It doesn't happen too often, but it does indeed happen. Once the verdicts come out, it's at that point in time that the judge can, well, after the plaintiff presents their case, after the defendant presents their case, the attorneys will ask for a directed verdict saying, look, based upon all this evidence, we should win right now. There shouldn't be any more of a trial. We should win, without it even having to go to the jury. Most judges don't do that unless it's so clear. But the judge wants to give it to the jury. So they reserve decision generally on those, which give them the power later on, if they want to get the jury verdict and then overturn that jury verdict by granting one of those motions. Once the jury comes out, they will read off of a questionnaire. There'll be a series of questions that get asked to the jury. Was the defendant negligent? And they'll check yes or no. Was this negligent a contributory factor to the accident or to the injuries? And they check yes or no. And they go down that series of questions. Depending on their answers, that'll be the verdict. And then they'll ask what damages they find, pain and suffering, future pain and suffering, things of that nature. And there is the appeal process throughout all of this. On any motion, on a trial, we can appeal the decision of the court. That is expensive and it's a huge delay. We try to avoid that unless it's totally wrong. such as, certain summary judgment motions, maybe a threshold motion where, the person sprained a wrist and it healed and the judge just wasn't in the mood and, denied our motion. Might want to consider appeals. Those go directly up to the appellate division. So, and in New York, it's the civil courts, and we have the Supreme Courts. We talked about those threshold amounts before. Then it goes up to the appellate division in New York, then the Court of Appeals. The civil courts, they go up to the appellate term, which has what we call concurrent jurisdiction with the Supreme Court. So from the civil court, you're basically appealing to the Supreme Court. And then from that appellate term, you can go up to the appellate division. Court of Appeals generally doesn't get involved in this stuff. We have to get permission to go to the Court of Appeals. And that's only for really like policy things of that type of nature. And that ends our presentation. Christine, you have anything you want to add on trials?
No, I just think that I think each of those bullet points, there could have been
Date.
probably at least 40 minutes of like, discussion. I think you did a good job going through it. But I do think that the most important thing at that stage is preparation
Prep.
and a simultaneous eye for treating this almost as like a business decision as well, in terms of our jury verdict assessments in a particular venue compared with the injuries that we're facing, compared with our exposure. Are we going to roll the dice and let a judge decide this? Are we going to really put this in the hands of a jurors with an unfavorable witness, or so on and so forth? You're really looking at all of this, each of these stages that we've gone through thus far. I think there's micro analytics, but then
Yes.
really you want to keep the background big picture going.
Mhm.
And that all comes into play in terms of settlement negotiation, that comes into play in terms of maybe it's not at this point worth our while to push it to trial, and these are all decisions that ultimately the adjuster will make, but we're pretty strong about our recommendations at these stages. We take
Yeah.
everything into
Yeah.
account going up,
We
leading up
know.
into this point, and then getting to trial. I think, sometimes we push for trial because we think that, we shouldn't settle a particular case,
Absolutely.
even when the
Absolutely.
judge is stressing it. And it's
Yeah.
funny, like I think you mentioned this before, but a lot of the time the court, because I think of how many cases they have in front of them, do tend to gently push
Well,
settle.
let me say this, maybe I need to be careful because I have been behind the scenes in the chambers, listening to the judge negotiate with these attorneys. And let's just say that they do prefer settling the cases
Right.
best that they can. And look, relationships, I know we keep going back to that, but let's not forget judges are human beings just like us. And they can have a particular pet peeve for one particular attorney, and there's nothing you're going to do about it. And they're just going to give them a hard time. They do. I've seen it time and time again, you
Yeah.
know?
And
And
there's also strategies with it in terms of knowing when to, like,
shut
when to
up.
hold them and when to fold them. Yeah.
Yeah.
I mean, really, that's comes into play too. Street
Sometimes
smarts.
silence is good. And as the adjusters, when your attorneys come to you and tell you that you ask, what's going to happen at trial? And they tell you, we have no idea. Once we pick a jury, anything can happen. They're being honest, that wacky things go on. They award damages where you didn't think they were going to give anything, or they did nothing where you thought they were going to award damages. So it's definitely a roll of the dice, so to speak, oftentimes, because both sides are going to go to trial. They think that they're right, and they probably have good grounds to think that they're right. So, yeah, it's really getting the rapport with the triers of fact and doing things right. Doing the procedure in the courtroom properly. I had a juror that didn't like the fact that the attorney was getting objected to when they were trying to put documents and business records into evidence because they weren't following the procedure and weren't using the right catchphrase for getting these documents admitted, and it just aggravated the jury, and they didn't want to hear the guy anymore. So, I mean, these are had nothing to do with the facts of the case, just the performance of the individual attorney that day.
The performance is
Yeah.
true. That is very, very true. And I think us as a firm, we just try to be very spot on with our performance, right? Regardless of what's going out on outside our job, we're in the gym, we like, we eat right, we get our sleep. It's like that all comes into play too. It's not just the
Yeah,
preparation of the documents, it's the preparation of, you as a person. But I think, like you said, I think the preparation, our best preparation is not at the time of trial. Our best preparation as attorneys has to be from stage one, has to be as soon as you get that summons a complaint, really,
agreed.
because every stage is crucial. It's
Every
just
stage of the from the time we get the summons a complaint, our motto in the office is we're preparing for trial. Everything that we do on that file is a preparation for trial because the more prepared we can be, the better it's going to be and the better settlement numbers we're going to have.
yeah,
All
I
right.
agree.
This is our overview. If you have questions or you want follow-ups on something, I know there's a lot to be covered. There's a lot of material. If you have a particular section that you'd like more information on, shoot us an email, just give us a shout and let us know and we'll cover it up in a supplement. Christina, have a wonderful day.
You
Today
as
is a
well.
good day.
It is a good day.
Have a good one. Bye-bye.
Bye.